Stripes and bright stars through the perilous fight. O'er the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Well, we have a full house today, and I guess that's good for our speaker, and it should be a very interesting day. Bill Culp is going to introduce our speaker today, and hang on. It's too bad to hear about the passing of Rod Gardner. He had a chair here in the room, and it was his chair for many years. And I've been here about 16, 15, and he was always really pretty much in the same seat. So it'll be a freed up place for him to think about. Norm Clark, I don't know if you remember who Norm Clark was, but Norm was the fellow who used to take the pictures at the meetings. You might have remembered him, and he always took pictures of the picnics, and he was like the unofficial official photographer of the club. That's who Norm was. Bill is going to introduce the speaker today, and I'll turn this over to you, Bill.
Okay, thank you. Very glad to have Linda Sekely, Esquire. She is experienced with 30 years as a estate and elder law attorney in Pennsylvania, senior partner of the law firm of Linda Sekely and Associates. She is also a radio host. She's an author and publisher of 6 books on estate law and asset production, and a national speaker and trainer of elder and estate subjects. So give her a big hand and welcome her on.
Hello, everybody.
Hello.
Can you hear me?
Oh, yeah.
You probably can hear me without this. Okay. You know, I'm going to share with you today some practical tips. 10 tips you can't die without. How about that? Before we get started, does anybody have a dollar? The rich ones are always in the front. Does anyone have a dollar? The bag is empty. They're reaching. Anybody who's wearing shorts can give me a dollar. How's that? Bag is empty. And it goes, what's the magic word? Donuts. Reach in and see if your dollar's changed, Ken. What do you have? $10 bill, and the bag is empty. Say, "Aw!" Oh. I need that back, Ken. Don't get any ideas. Okay, don't get any ideas. Reach it in there. What's the magic word? Donuts. Reach in and see if things changed. Got his dollar back, the bag is empty. Oh! Thank you, Ken. If the law ever dries up, this is the career, right? So, what's the point of that exercise? We don't want any surprises. We don't want surprises. We want to be able to control where our estate, our assets, our heirs, our desires go, even after we're finished here. So when somebody comes into my office and says to me, "I hear you do a lot of trust work," I'm interested in talking about a trust. The first question I ask them is, what are you trying to control? Because there's always an answer. I'm trying to control my grandson who is bad with money. I'm trying to keep the money in my bloodline, no in-laws. I'm trying to provide some protection for nursing home admittance. I'm trying to control something that is beyond our control when just a will is the testamentary document. So, I'm going to do a spatter of a couple subjects. And you know how they say you never can say never? Well, I'm going to say never a couple times. You never name a minor aged beneficiary on life insurance, IRA, 401k, annuities. Anybody under the age of 18, you never name them directly. Grandparents who are naming their grandchildren as a beneficiary on life insurance, never do it. Because that sometimes requires me to go into court because we have a minor child that cannot administer that money. So what do you do instead? You use a type of trust, even if it's within your will, that addresses that minor child's receipt of that money and holds it safe and secure till maybe they reach age 25, not 18, you see? Another way to control, okay? You never have a power of attorney that only lists one person as your agent. You always want a Miss America and a runner-up, okay? You never list just one. You never want a power of attorney that doesn't contain the word durable in it somewhere. On the front page, on the second page, on the last page, the word durable, like fabric, durable. It has some connotations when it comes to nursing home planning and when it comes to incapacity. So it's important that your power of attorney have that word. You never don't review the power of attorney. You never fail to review it. If you signed it before 2007, there were some pretty big changes to the form. So check the date you signed this thing. Then there was another run of changes in 2015. So it's probably good to have a set of eyes just review it to make sure it's still the best that you can have in Pennsylvania for all the items that you want it to do for you. And don't forget too, if you are a business owner or if your son's a business owner or that, they don't know who to name as their agent because they have so many different interests. Their health, their personal money, their business, real estate. They can name different people to do different jobs. Just have one, okay? One time I did a power of attorney that listed 7 people to do 7 different jobs. And it worked just fine because that's what that principal wanted, was 7 different people. So you pick the ones that are best at it. Now, so there's a couple nevers. Never think it's too late. If your brother, your friend, your wife, somebody is taken into skilled nursing, never think or assume it's too late. I'll share with you now one of the most popular planning tools for the nursing home. Whenever you think there's nowhere to turn, you don't have those 5 years to take assets and put them out of your name, what are you doing now? What's some emergency choices? One of them is called a personal caregiving agreement. And what that is, it allows us to move money from the parent to the children, but not as a gift, like what it is that gets us in trouble if we do within a number of years of the nursing home. So there's a small contract called a personal caregiving agreement that accompanies that money that says this kid or kids is not receiving this as a gift. They're going to assist the parent. Companionship, doctor's appointments, help them with their bills, visit them in the nursing home. There's a list of 1.5 pages things that people can do for their relatives, okay? And that transforms that money from being a gift to being payment for an obligation. And that is an emergency way that you can move quite a lot of money. So it's never too late. So that's the never. One time I spoke in Las Vegas, and there must have been 2,500 people there. And I said, please raise your hand if you've ever been to a nursing home. Well, everybody raised their hand. I said, keep your hand up if you think it's going to be you. Well, there were about 10 hands up. Don't we know that that's not the statistic at all, you know? But it's never going to be me. It can't possibly be me. My kids know never to put me there. It just doesn't work that way sometimes. So we want to be able to have some of that knowledge that it's never too late. If you have any veterans who are your friends, particularly World War II, Korea, right now those are the two wars we're dealing with, there's a program called Aid and Attendance that will get that veteran about $2,000 a month tax-free for them to help with their medical expenses. And if they're deceased and they have a widow, it could get her about $1,700 a month, tax-free. And this is what you have to be to get it. You served at least 90 consecutive days in the service, and at least one day was during a period of war. You don't have to have seen battle, but it has to be during a period of war, one day. And then there's a special trust you can use so that you don't get disqualified for having too many assets. So for a veteran, it's a win-win. I wish there were even more programs for those folks. But just keep it in mind as you hear about somebody. Medically, they have to have help with at least 2 daily skills. But they can be living at home. They can be in assisted living, they can be in personal care, they can be in nursing home, or they can be living at home. But they have to have help with at least 2 things you do in the morning when you get out of bed. You get out of bed yourself, you take a shower yourself, you feed yourself, you take your own medication yourself, you do your own bills yourself, okay? You don't have any incontinence or to have any mental challenges. 2 of those, you can qualify for this program. So people are qualifying at home for it. So that can be substantial for veterans. So you never think that there's no program available just because you have too much money to qualify, because there are trusts that deal with that. Okay? Now, living will. Do we all know what a living will is? That's the one that says if I'm in a condition, a very specifically defined condition. The key words there are permanently unconscious with no reasonable expectation of recovery. So whenever you're sitting in front of a living will and you're asked to make your choices, I do want this, I don't want this, all those choices in the center, most people, when they really read that first paragraph, check do nots. Most people, 98% of the people. 2% mark hydration, the other 98% mark no. And I'm going to give you a little tip about how I came to understand this living will. I have a lot of clients who are physicians or retired physicians, and they always put do nots on their living will. And I always say to them, is there some tip you can give me when people are torn about this? And they say to me, when you are asleep at 3:30 in the morning, do you know what you're thinking? Do you feel alive? Do you feel awake at 3:30 in the morning when you're sound asleep? I say, no. I don't even know what I was doing at 3:30 in the morning when I was sound asleep. That is the brain activity. Okay? So that kind of helps some people with this particular form. So if you're able to talk for yourself, it's irrelevant. It's only in that situation where we have the life support area. Yes, you should do one. Even though the law recently changed and set forth an order of people that can talk, just because they can talk doesn't mean those selections were made that are coming from you. Do not do this, do not do that, and all of those instructions. So yes, do one. It's 2 pages long. It's worth doing. But that's the tip when you're stuck on what to say. Now, I want to talk a little bit about deeding real estate to our children. Okay? There are a couple circumstances where it makes sense to do this. One is a nursing home tip. If mom lives at home and her son lives with her, She goes into the nursing home. She's single. There is no problem with that house being counted as her asset, but her son has lived there at least 2 years in that house. There's something called the caregiver exception that allows us to deed that house to that son, and it never is counted as an asset for mom. So when people come to me and they say, I live with my mom, she's not doing very well, I'm afraid I'm going to lose my house if she goes into a nursing home. The answer is easy. Caregiver exception. Deed the property to the son. If there are other kids that would find that unfair, the son can sign an intent to share the proceeds if she passed away with the other children. But just get it out of her name is the trick. Okay? So that's one reason that you do that. If the child does not live in the house, look before you leave when you are deeding the property, because I've done this for now 35 years, and I've seen my share of property that has been deeded to a son. Son gets divorced, son is in a car accident, son is sued by somebody, son went through bankruptcy, house was in jeopardy. See, mom's left. There are better ways to do it. I'm going to share one with you. In Pennsylvania, we have a special kind of trust name, and it goes hand in hand with a revocable trust. Your standard revocable trust that everybody in the building should have, from the receptionist behind the counter to the most highly paid executive of the YMCA nationally. Everyone should have that. It goes hand in hand with it. But what it does is allows you to take your house that you live in, just your house, no beach house, no hunting cabin, no rental property, your house, put it in the name of a special trust that's within your trust, and that starts those 5 years ticking. Well, you're not even paying attention to it. 5 years in 1 day is as if you never owned that house. It is safe from liens, from asset inclusion, period. Those 5 years, how fast do 5 years go?
Very fast.
Of course. So why not, while you're avoiding probate on that house, and you're reducing inheritance tax by about 20% on that house, why not have the 5 years ticking too? Okay?
What if you're holding it by the entirety?
That's still okay, but the second one, there'd be a lien taken against the property. I'm trying to protect it all the way through. So that's a tip when it comes to the residence. It's a protective residence title, okay? And that's just for your home, not anything else. Did you also know that if you have rental property, a lot of people have rental property can be excluded from having to be reported to the nursing home if it generates income or is hoping to generate income. So the trick is you have a little piece of 2 acres or something lakeside that you go up. You're not really renting it to anybody, but here you go going into a nursing home that you have to claim that property. You put a for rent sign on it because you're renting the land just for people to care about, and you can exclude it. So it's a lot of things you can do, even if you have more than just a residence when it comes to real estate. Okay, now, trusts. If you look on the internet, the way you look at anything on the internet, you're going to come up with countless opinions, pro, con, etc. I can only tell you that I'm a planning-based attorney, which means I do a lot of trust work versus just simple wills. I do a lot of trust work. And if you're wondering, well, I heard that the cost of probate is not that bad in Pennsylvania. Well, I'll give you an example. If you think of everything you own, give it a number, $1 million, $800,000, whatever that number is. Attorney's fees, they're about 5% of that number. The cost to file probate filings in the court, they're nothing. But your appraisal costs, your attorney's fees, those things can be substantial, as well as publicity. With a will, everything's public. your daughter's social security number, her address, what's in the house, the appraisal of everything, it's all public. So that invites crime, either for identity purposes or just being able to stake out a property and know where all the kids live, put one thief at each house, and go in and get the property. So it's very tempting for that kind of activity. The trust, it does not become part of the public record in the courthouse. So it's protective of your surviving spouse and your kids when it comes to information being shared. So, although sometimes a trust might not be appropriate, like maybe you're single and you're giving everything to charity, you might want the court to be involved in the probation of that estate because it's all going to charity and they can supervise it easier. But if it's loved ones, small charity, usual estate, you want to analyze whether a will or a trust is appropriate for you. A will takes about 2 years to probate on average in Pennsylvania, some longer, some shorter. The trust is as fast as the trustee wants to move. Now, how does the trustee know what to do? People ask me. Don't they need to go to a lawyer anyway? What are they going to do with this 3-ring binder that has this trust in it? Well, in the trust that I do, there are instructions for the trustee. Step by step, what do they do in their role as a trustee? Step by step, what don't they have to do in their role as a trustee? No appraisal of any of the jewelry, cars, guns, antiques, real estate. They're taxed for real estate purposes on the assessed value of the property, not fair market value. So we're going to be knocking tax down using a trust versus a will. Not eliminating tax because you're still in control of your assets, you see. So that's what we're looking at, is that difference in role between an executor and a trustee and the need to have legal counsel or not, okay? So do you consider it? Sure you do. Is it jumping off space in case of a nursing home issue? It's the privacy, it's the expense, it's that flexibility. You can still be in charge. You do not have to have an irrevocable trust, although all of my trusts can be converted to irrevocable if you choose to later. But this you start out usually with you're in control, revocable trust. And then there's always confidentiality about personal property. One of my favorite Sekely stories is I had a very dear client of mine, and he invited me to dinner in Sekely with his extended family so I could present the estate plan that I did for him so they all knew what was happening. And then after dinner, he said, everybody but Linda, look under your plate and you'll see a little Post-it note package. You have 30 minutes to go through the estate and mark the items that you want me to give you in my documents. 30 minutes. And if there's anybody that wants the same thing, we'll decide how we're going to do it today. You have 30 minutes. Go. And they all looked at me and I said, well, go. And he and I sat and laughed at the mayhem for 30 minutes. And everything was marked at the end. Every work of art, every vase, every gun, everything. He did not want anything left to disagreement. And he did a trust, of course, because it's a very large estate, and he didn't want appraisal of all these things. He wanted to go quietly to these people who marked them with the Post-it notes. Okay? So that's one of my favorite personal property stories. And he protects that anonymity of all those items by having them passed without going through the court system like a will. Okay? So it's food for thought. Okay? Now, I'm going to take a little break and see if there are any questions. If they're not, I'll do a couple more subjects. But I want to take a little break and see if you have anything that you, yes?
If they're not a relative, can you still take care of them that way?
Yes. You can't transfer the property under that caregiver exception. The real estate, it has to be a son or a daughter, but it can be anybody for the personal caregiving agreement. Nephew, niece, neighbor, friend, mother, anybody. Yes, sir.
Suppose I do what you said. Put our house in trust for my son. And we're turn around after 5 years, and I'm no longer in the picture. My wife transferred over her nieces and nephews instead of my son.
Yes, because she's still the trustee, unless you say in your document, it is irrevocable at the first death. And then nothing within that trust can be changed. Which some people like, because that serves as an unofficial prenup.
That's close enough.
Yeah, like a prenup for the next wedding. You see what I mean? When the wife remarries. That's what I'm talking about, yeah. Yes, sir.
You make the case for a trust as opposed to a will. When is a will better than a trust?
When a lot is going to charity, a large amount is going to charity, or the person has no real estate. They just rent. There's not a lot of things to be appraised in the estate. Or if they just don't want the complexity of having to give the little letter to the bank that says, please put my trust on there, they're just afraid of that complexity. So usually it's because the estate has a mix of assets that can stay simpler. What's your most important document you need to have while you're alive? Power of attorney. Yeah, absolutely. Yeah. What's the word? It should be on it somewhere? Durable. That's excellent. Somebody's hand? Yes, sir.
Will you talk a little bit about the costs, including the taxes of using trusts?
Correct. The income tax effect of using trusts is no different. I've had my revocable trust since I graduated from law school 32 years ago. And my 1040, my income tax return, still uses the social security numbers of my husband and I, so it looks the same. The assets are just in the name of Sekely Revocable Trust. So I still get my 1099s from my broker, from my bank, or wherever, but it's just in the name of that trust. So the income tax rates do not change. The inheritance tax rates don't change either. When husband dies, wife, tax-free, inherits everything. When wife eventually dies, kids inherit it at the low rate of 4.5%. But with no appraisal of personal items, no appraisal of real estate, no inventory of all the assets attached to the return, you save an average of about 20% in inheritance tax when you don't go through probate. But you still have some tax.
And then the trustee's fees.
Trustee fee is taxable on their 1040 and deductible by the trust. Sir?
What about living trusts?
That's the same as revocable trust, just a different name, like physician and doctor. They're the same thing. They can be called a family trust, a living trust, a revocable trust, a just trust. They can be called anything. They're all the same when you have the power to be the boss. Yes, sir.
You opened your talk about not putting minors.
Yeah.
What about a generation skipping trust?
That is rare because the exemption is so high now. You know, the federal exemption is so high. As long as that trust holds those proceeds out of the hands of that minor in whatever, a generation skipping trust, a regular life insurance trust, even your revocable trust, it's going to work because their hands are the thing that taints it because they're not old enough to control it. And some insurance companies will release it when they turn 18. So what would you buy if you turned 18 and got like a $500,000 check? The fastest, reddest convertible with a blonde next to you? What would you buy? You know, so as long as it's being controlled by a trustee, the trust can take many different forms. Just not the kid. Yes, sir.
Correct me if I'm wrong, but I understand that an income-producing annuity or a pension is not subject to assets. Okay.
It's non-probate.
All right.
Anything with a beneficiary.
So a husband and wife situation. A husband gets notice that the lights are going to go out in a relatively short period of time. He took all the cash that belongs to him and put it in an income-producing annuity. Is that subject to the 5-year look-back, the money that you put into it?
No, if your annuity is what's called a Deficit Reduction Act compliant annuity. There'll be a test later. Deficit DRA compliant annuity is a special thing they came out with that said, I don't want you to be able to do what he just described. But if you're married and you have a big pot of money, they count both husband and wife's money. The trick is you do an annuity, either to the spouse or the kids, that complies with that tax act, which means it has to be an immediate annuity. It has to be based on their life, so you can't buy an annuity for 70 years when the person's 50 years old. You see, it has to be reasonable and based on their life. And what it does is it counts the income coming out, but doesn't count the big principal balloon. So you have to comply.
To hide your assets when you run personal.
You have to comply with the DRA compliant annuity. And there has been a famous case called the Weatherby case that changed everything in estate planning. And what it said was this: husband and wife have a lot of money in joint name. It's all going to be counted in the nursing home. So we're going to transfer into a DRA compliant annuity on the wife's life $500,000 or whatever it is. Now, income from the community spouse is not counted for the husband. So we are on her life. It's that kind of annuity. It was allowed to be. So we've removed that and kept it safe from his column. So if you're married, that's very powerful. Very powerful. You can't do it for real estate, but that's what other trusts are for, is to be able to title up.
Question, how specific do you need to be in your living will? I mean, like, if you're saying don't pull the plug, but if there's a chance for me to come back,
Yeah.
then don't pull the plug. How
Well-
specific do you need?
Mine, the specifics that I use are if you are permanently unconscious, which is defined in Pennsylvania as problems with brain waves supporting themselves. You are unable to communicate yourself, and you are in a condition that has no reasonable expectation of recovery, determined by 2 physicians. Because you know you're going to have a team of doctors. Nobody ever has one doctor in the hospital. You know how many you have? 67 doctors that come through your room? You know, so you're at least going to have 2 doctors, you know. If that's it, then Pennsylvania at least wants you to name a surrogate if you want somebody to be your spokesperson. I always say Miss America and who? Runner-up, right? Absolutely. And then Pennsylvania at least wants you to address tube feeding, which is pretty controversial. Mine has about 8 items. I do not want dialysis, antibiotics, tube feeding, all of these, invasive surgery, you know, and most of the time it's all do nots. I think the more specific you are with the definition of the medical condition, the more vague you can be. I think you have to get really specific if you're just going to say, if I can't talk for myself, then this. I like that no reasonable expectation of recovery, because you've heard the stories of people who come out of unconsciousness. Yes, sir.
In trust, you want to leave money to minors. What happens if they're in another state?
That's okay.
Don't
Your
they
trustee would serve as the trustee, and in the trust, you would want to make sure that it says the trustee is not required to post a bond in any state. They can then govern that money for someone who lives in Alaska. It doesn't have to be all Pennsylvania residents. Your trustee can live in Alaska and govern the money of people in Pennsylvania. You see? So it doesn't matter. The estate's based on your residency, not where the beneficiaries live, for purposes of tax, probate, etc. Yep, sir.
You recommended having a second person with power of attorney. Who has seniority if you have more than one? I mean, who makes decisions?
The first named person, because the language says if he is unable or unwilling to serve, then I name Sally second. You see? So Frank first, and if he can't serve,
I only have one now, so you got to think.
yeah, put your thinking cap on.
Yeah.
You don't want to have the problem of, well, she's not there, she's out of town, she's passed away, you know, and here you are in the emergency room, you know, so you kind of want to have that covered in some way before you can't do it because you're unconscious, even temporarily, you know. When my husband was operated on in Allegheny Valley, AGH. They made me show them his power of attorney before I could speak with the surgeon about the results of the surgery. I was the only one there. They still made me show it. So it depends on the last conversation the doctor may have had with his malpractice insurance as to whether he's asking for that or not, frankly. You see what I mean? Frankly. So it's a lesson to learn. You know, it happens every day and sometimes doesn't, sometimes it does. Yes, sir.
One of the things I faced was second marriage. My wife has one daughter, I have one son. What we did is name each of them as trustees. And the third one was the lawyer.
Okay, that's fine.
She'll keep both of them straight.
That's fine. The only requirement for trustee or executor in Pennsylvania is over the age of 18 and a U.S. citizen. So it can be, doesn't have to be related to you, or it can be related to you. That's the only requirements are those two.
I don't think most people realize what a nightmare it could be.
Yeah.
If you don't have a power of attorney,
Oh, yeah.
and you don't have things written down. I know a person whose brother died. She didn't even know where his pension was coming from. Had to go to court and get it. I mean, it was a nightmare.
Yeah, yeah. I think that's why so many people are turning toward, like, when I do a trust, it's a 3-ring binder that has my contact information on it. Inside are tabs that my clients told me they wanted to see. Living will, power of attorney, will, trust, memorial instructions, life insurance policy, where do I bank, you know, all these, who's my pension with?
Yeah.
And people just sit and fill it out and they tell their kid anything happens, but what book is located there? And people have acted very nicely. They use it themselves. They put their homeowner's insurance person's card in there and they're all set to go. So it's coordinating it in one place that makes it a little less stressful for everybody. Okay, any other questions? Sarah?
Same problem, second wife, and she's an executor of the trust along with, I can't remember if it's the bank or a company, is that?
They charge fees, as you probably know. The bank or a trust company charges a fee. Is the reason that you made her a co-trustee because you don't have anybody on your side that you want to be co-trustee with her? You don't have any kids on your side of the tree?
That would be good.
It would be less expensive. Yeah. And you know what's interesting about second marriages is often I'll do separate trusts for the husband and the wife because they want to make sure what they grew in the first relationship goes to their kids from the first relationship. You see what I mean? And the beauty of a trust is we're not going into court to resolve anything, and we're kept separate by the fact that we have separate trusts. You see? So sometimes that works out to be the cleanest way to address it. You know, so that's very common these days.
It's all right the way it is, you're just saying it's more expensive.
It is, it is. But you can always find out their rate because they have published trustee rates in every bank and trust company. So you can ask them for it.
It's 50-50, is that a good way to do it?
Yeah.
Or I don't know, two trustees.
If it's just as co, it's already 50-50. Yep. If it just says she and this bank, it's already 50-50.
And what if you have long-term capital gains
Yeah.
that will be will upgrade when you die so that people have to pay less taxes on it?
For the wife or for which heir?
Well, whoever the heir would be.
Correct, right?
They have the stepped up basis, so they don't have to pay taxes on the
Correct.
difference, on the money that was accumulated during your life.
Correct.
Now, how does that affect your estate?
It doesn't. It doesn't affect it. Because you don't get one with your wife. She already would be on it if you had it joint or in the trust. But if it's going to your kids, for example, the piper they pay is inheritance tax. That's the price they pay to get that nice step up in basis. So their capital gain is probably 0 to very little. So it still preserves the same tax treatment. And it's usually the kids that hit with that, the next generation. They have a step up in basis because they paid their 4.5% in inheritance tax, which usually is less. Usually is less. It's good. Yes. Yes, sir.
How important is it to have nursing home insurance?
Oh, if only we all knew what that was when we were all 40 and we bought it. I think it's critical. Why I think it's critical is at-home care. It provides for at-home care. Now, you go to anybody in a nursing home, and you ask them, would you rather be here, would you rather be at home?
They want to be at home.
Long-term nursing coverage pays for at-home care so you can stay home longer and preserve your assets. You see what I mean?
Right.
I mean, I think it's critical. I think as you get older, it's harder to get, more expensive. You have pre-existing conditions. I wish we all knew at age 40. I wish it was required to get it at age 40, but it wasn't. And now it might be too expensive for people, you know. It's important, and that's why I think. Yeah. Any other questions? Okay, I'm going to wrap it up. I think I'm on time, right? I think I'm doing a good time work. Now I have some brochures back in. Oh, sir, yes.
Where can I get that hat? You put $1 bills in.
This is for sale in the back for $50. I have some brochures in the back. Please help yourself. You're going to read a little bit about me, because you know this is all about me. You think it's about you, but it's about me. So if you want a second set of eyes to look at your documents, give me a call. There's no charge for that first meeting, just to see what your questions might be. Or if you have some questions, you need to research anything or take a look at what happens in the nursing home, how do you qualify for Medicaid, sit down with me, we can go through it, or if you need documents, definitely. So I invite you to do that, and then it'll be one of my offices. I have a couple offices. My main office is in Westview on 19. Then I go to Cranberry, Monroeville, Foster Plaza, and Johnstown. Any takers for Johnstown? Sir. I couldn't hear at all.
Could you repeat?
I couldn't hear, I'm sorry. I didn't. There you go.
My question is, you mentioned originally about a veteran who may need help in doing things in the home. Is able to get something from the government?
Yes.
What is the application, or what are the conditions that has to be?
It's called aid and attendance. And the service condition that I mentioned was you have to have been in the service active, not a reservist, for at least 90 consecutive days, and at least one day you were in during a war period. Now I'm doing a lot of Korea, you know. And when you're at home, you have to have help with at least 2 of the things that you do daily.
And it's called aid and...
Aid and attendance, yes. And they'll wire the money into your account. They don't care how you spend it. It's not like Medicaid, but they pay the nursing home. The VA pays the veteran, or the veteran's widow, not the wife. She has to be a widow, see? Powerful stuff, sir.
I know, when I was in the 6-month program, so I still qualify for that.
90 consecutive days, yeah.
That's after 6 months.
And at least one day was during a war period. Now, let's talk about Vietnam. Let's talk about Vietnam. You have to have boots on the ground at least one day for the Vietnam vets. Don't ask me why. I think it's a matter of numbers.
Boots on the ground where?
One day, in country.
In Vietnam?
Yes, in country. Versus the other times, you don't have to even seen battle, as long as you were in the armed forces one day during the war period. So I don't know why the discrepancy, but it's not fair. Surely not fair. Sure.
These were not designated as official wars. They were never declared.
That could be. That could be. But they say specifically, you can still qualify, but you have to have boots on the ground for Vietnam. You know?
You have to be in the boots?
Yes. You can't just mail them over. That's right. Although that's an interesting